Hi, so our group will present two cases in end of chapter. So my name is Melanie Rika, anak Lukas Jalan, number matrix 20 D8023F1042.
Hi, my name is Erica Elise Anna Moses. My metric number is 20 D8023 F1054.
Hi, my name is Kalvina Anjay Anak Bumahan. My matrix number is 20 D8023F1058.
My name is Diana Prila Naunting, matrix number 20 D80 23F1024.
For question 1, Elena, whose career as an accountant for more than 2 decades, has been employed as the director of Tradex Berhad, an investment company. In discharging one of her main duties, she is required to prepare the financial statement according to the basic standard guideline and framework. So Elena, however, had negligently prepared such documents where it involved a series of major misstatements and miscalculation is would never to be expected from Elena, who was deemed to have a vast experience in the practice. Advise Elena accordingly. The issue whether Tradex Berhad can sue Elena for the damage. From that case, we take section 165 of Contract Act 1950, skill and diligence required from agent. Refer to section 165 of Contract Act 1950 mentioned that an agent is bound to conduct the business of the agency which has much skill and is generally possessed by person engaged in similar business unless the principal has notice of his want of skills. An agent is always bound to act with reasonable diligence and to use such skill as he possesses and to make compensation to his principal in respect of the direct consequence of his own neglect, want of skills or misconduct, but not in respect of loss or damage which are indirectly or remotely caused by such neglect, one of skill of misconduct.
The relevant cases is Keppel against Wheeler, 1927. In Keppel against Wheeler, 1927, the defendant was employed by the plaintiff to sell his house. An offer was received and accepted by the plaintiff, subject to contract. A few days later, a higher offer for the same property was made by X, but this offer was not communicated to the plaintiff. A written contract of sale between the plaintiff and the first offer was duly signed. For the the court held that the defendant was liable to the plaintiff for the difference between the two offers. Difference is that the agent must disclose everything coming to his knowledge, which is likely to influence the principal in the making of the contract.
In conclusion, Elena should pay for the damages. Section 165 of the Contract Act 1950 requires agents to conduct their business with the same level of expertise as others in related business, unless the principal is aware of a lack of skill. The agent is responsible for acting with reasonable diligence and using their skills. They must compensate their principal for the direct consequences of their own negligence, lack of skill, or misconduct, but not for indirect or remote losses of damages. In Keppel against Miller, the court determined that the defendant was accountable to the plaintiff for the difference between two offers. The agent is expected to disclose any information that may influence the principal's decision to enter into the contract. In this situation, Elena should be held responsible for the damages.
Hello, now we go to the question number 2, which is Aiden want to sell his Range Rover to any interested party in order to raise his personal fund. Through an advertisement, he had coincidentally met his old friend Danny on 24 April 2024, who is agreed to buy at the price of 2,050 250,000 ringgit Malaysian. Convinced the Danny to settle the payment in full on 1st May 2024, Aiden had immediately transferred the car to Danny in the same day. Unfortunately, there was no payment effected on 1st May 2024, and Aiden therefore realized that he had been cheated. Aiden tried to claim the car from Danny on the next day, but only to discover that it had been sold to Lisa, a third party who bought in a good faith. Advised Aiden accordingly. The issue for the question 2 is whether the Aiden can claim his car. T7, where a person having bought or agreed to buy goods obtains with the consent of the seller possession of the goods or the documents of title to the goods, the delivery or transfer by that person or by a mercantile agent acting for him of the goods or documents of title under any sales, leads, or other deposition thereof to any person receiving the same in good faith and without notice of any lien or other rights of the original seller in respect of the goods shall have effect as if such lien or right did not exist.
The relevant case is Newton Wembley Ltd against William. Plaintiff, the true owner, sold the car to the first buyer. Payment was made by check. It was agreed between the parties that the title would only pass when the check was honored, but the plaintiff had given possession of the car to the first buyer. The first buyer subsequently sold the car to the second buyer, who in turn sold it to the defendant. The check was dishonored and plaintiff attempted to recover the car from the defendant. The first buyer, who was in possession of the car with consent of the true owner, could pass a good title to the second buyer, who in turn transferred it to the defendant. Plaintiff action failed. He could only claim the price from the first buyer. To summarize, Eden cannot claim for the car, but he can claim for the first prize money from Danny. Section 30, subsection 2 of the Sale of Goods Act 1957 state that if a buyer obtains possession of goods with the seller consent and transfer them to another person in a good faith and without notice any lien or other right, the seller consent is required. In Newton's Wembley Ltd against William, the court ruled that the first buyer who had the car with the owner consent may transfer the title to the second buyer, who then transferred it to the defendant. Plaintiff action was unsuccessful. He could only collect the price from the initial customer. In this situation, Eden cannot claim the car from Lisa, but can claim the first prize money from Danny.